yes. I restocked the little bucket of treats here. I got out the big box. So, today I stumbled across the hearing, and the guy was a nutter. I'm like, I must know more. Well, we have 7 times more. Because, yeah, I went through and I found everything that I could. So we're not gonna spend a whole lot of time chit-chatting tonight, because it's an hour and 40 minutes, and yes, I'm sorry about the late notice. I fell asleep at my desk. It was about 10:45, and I was like, oh, I really need to set an alarm clock. I need to set my alarm. I need to set my... and I was out. So, yeah. I just glad I woke up in time. I woke up in time to see Jerry's message saying, oh, no live tonight. Or something to that effect. I think it was a little bit more, grumpy. Like, guess not. Hello, Jerry Matthew Boyd. Hello, Jenny Green. You gave up on me. Hey, what are you doing? Don't nibble my toe. That was the weirdest feeling ever. What are you doing? Why? What are you doing? If you toot one more time. Doggy for sale, only 50 cents. Hello, Wire Mother. Hello, Mortimer Duke. Hello, Jenny Green. Drive safe, Morty. Hello, Eileen and Carlin, honey. I know. I'm sorry. They don't get into like tons of graphic details. It's just a fact that you know. The fact pattern and the course of the case was something that I just couldn't ignore, though. It took some twists and turns and stuff along the way that, you know, the law library gonna law library like that. It'd be like that, though. Oh, yeah. Oh, that's probably why I went snoozy snooze. I took Dayquil earlier because I'm snuffly still. Hello, Dark Zoomy. Well, we won't feed it all of the aliens. We have to keep some aliens for us. We'll only feed it, those aliens. Hello, Squishy. I know. Yeah, I do. I, I love everybody. I love everybody so much. Yeah. Yes, Earl. I tried hitting Squishy up to get this guy's arraignment all the way from March of 2025. Neither one of us had it. We searched the archives. Hi, buddy. What you doing? Hello, Nana Laura, honey. Definitely be keeping you and your daughter and your husband in my prayers. Hello, Penny. Hello, Charlie. I'm wearing my favorite shirt from my favorite brother. Well, I can't really say that. I have one decent brother aside from you. one decent biological brother, and then I have you. And you know, you're my favorite brother from another mother. Hello, Linda Adams, honey. You're not familiar with Woodchipper? No, any grown adult that has relations with a child, they're Woodchipper fodder. Hello, Mark Addy, honey. I say put them all in Gen Pop. Hello, Megan, honey. How you doing? I don't have the light on it. My bad. I'm still not fully awake. It's still dark, but lighter. Oh, thank you so much, Purple Kiv. I love you, honey. Oh my, that's interesting. I've not heard that before. Well, I didn't know what else to take for my snufflies. And I can't take ibuprofen anymore. Or ibuprofen related things. No naproxen, no aspirin, no ibuprofen. I was kind of in a little bit of heck today. But Dayquil's got acetaminophen in it, so I thought that would be a safe thing to take. It was. It just made me go zonk. Yes, the entire case, all 7 hearings. It's about a wood chipper, a lonely wood chipper. It was starving in a field, and you know, some lone prisoner guard found it, and together they made a beautiful couple, and it fed the wood chipper every day. I feel good. Da-na-na-na-na-na-na. Knew that I would. Da-na-na-na-na-na-na. No. Jerry, I hope everything goes well for you in the morning. I hope I don't keep you up too late tonight. You'll just fall asleep in your chair too. Hello, Spider-Man. Oh, you can catch us on the replay crew. Love you. You'd like mine. Her name's C-Rex. My adopted brother and my adopted mother. Well, and then I have Nana Laura, too. Are you kidding me? This is when they're up. From now until 4 a.m., they'll be running the house, pitter-pattering, and going absolutely crazy. Bonkers. Wild. Yeah, see? Earl agrees. It always does. It always does. Dayquil will knock me out. Yeah. I think almost all of us do. I did not forget you. I said hi to you long ago. I did. When I said you were something sarcastic in the Insomniac chat. Yeah, you missed it. When I was saying how oh my gosh, you're so big. When I was saying how Jerry said, I guess no live tonight, or guess not, or something like that. Something grumpy like that. Hi. Hi, Billy. Oh, sorry. I went to answer you and a yawn snuck out instead. No, it does not. No. No, it does not. It will put me out for a very long time. That was Billy O.T. That was Billy O.T. He was not thrilled. He was not thrilled with that. That little power move. But he couldn't resist. I had to show his beautiful face. Alright, guys. I'm going to put this on. I will do my best to stay awake tonight. I have not taken a replenishment dose. Boy, you're handsome. Hi, puts me out longer. And you know, he was the most emaciated. You'd think he would be the most grateful. No. See, Snitch and I are still in that honeymoon phase, you know, where he knows I rescued him. He is grateful for it, and he cuddles with me, he snuggles with me, and he lets me know that he appreciates me. You know, we have this little phase for a few months before they realize that they own me, and then they run my house. Hello, Buzzy Pug. There are no treats in there. There's just fur. Stop it. That's just fur. Golly, you're cute. Stop that. I will... Stop that. That is not treats.
I cannot see very well. Is that you, Mr. Papp?
Yes, Your Honor.
Okay, thank you. All right, we're on the record in People versus Carl Papp, file number 256857. The record should reflect that Mr. Papp is appearing today by video from Department of Corrections. If I could have counsel put your appearances on.
Yes, sir. People. Thank you, Your Honor. Richard Schuster, appearing on behalf of Mr. Papp.
All right, this is set for a status conference in this case today. Mr. Trush, can you tell me where this file is at here today?
Yes, Your Honor. So this is our first hearing after the bind over from discussions with Mr. Papp. We're still waiting on transcripts from the preliminary exam, albeit they should be fairly short because although it was a lengthy exam, it was over 2 days and the first day of it has already been completed. So really it's just a smaller transcript we're waiting on, at which point we anticipate filing of some motions. So I would ask the court for some time to do those things.
All right, what's a reasonable time frame based on the complexity of the motions that you need to draft and file?
Given that we already have, again, kind of the bulk of the transcript, I suspect 60 days would probably be sufficient for me to get the rest of the stuff I need, get the motion drafted and filed.
Mr. Bill, any objection to that?
No objection to the motion, but I would indicate for the record there was a plea offer of plea to count one for dismissal and habitual court enhancement. Should the defense decide to go through with their motion, that plea offer would be withdrawn.
Okay. All right, we got that for the record. So, Mr. Trush, I'm going to then put in the pretrial order. I won't set any trial dates at this point, but the court will put in the order that any of the motions that you're aware of at this time need to be filed and set for hearing within the next 60 days. And then the court will set this for a hearing, a status conference at that 60-day mark, just in the event that for whatever reason there are motions that get filed prior to that. Mr. Papp, did you have a question?
Yeah, it was, I also wanted the transcripts for the arraignment with Judge Cooper, not just preliminary.
Okay, Mr. True.
I don't know if those have been ordered yet, but I certainly can make sure they do get ordered.
Because that's,
okay, so
that's the one I really wanted, because that's the one that showed where Judge Cooper violated my due process.
Dag nabbit. And now you know why I really wanted to find that one too.
Okay, sounds like your attorney's gonna make sure that those are ordered, okay?
All right, thank you, Your Honor.
Okay. All right, Mr. Trush, anything else we need to address for the record today?
I guess I would just sort of indicate to the court that the direct motion that I tend to file is a motion to quash the bind over, at least that's what we anticipate. There is potentially, I think, an evidentiary motion regarding a trial. I don't know if that's ripe yet, and I probably have to do a little digging to figure out when the appropriate time to raise that issue is, but I just put it on the record because I don't know that that's going to be ripe in 60 days. If it's not, I'll address it to the court at that time.
Okay, and I guess I can clarify too. I mean, I'm looking at this 60-day cutoff as, you know, as pre-trial motions, not necessarily evidentiary motions that would address what could or couldn't be admissible at trial. So I'm just looking at preliminary matters. So, Mr. Rolla, anything further I can address for you?
Your Honor, thank you.
All right, Mr. Papp, did you have any questions about how we're going to proceed?
No, Your Honor, but is there any way that me and Mr. Truce can get put into a breakout room?
Any other files, Mr. Church?
I don't, but if the court has the time,
Yeah, I can put you guys, if you have something to sign in on.
yes, I can.
So, Mr. Papp, your attorney's going to sign in to Zoom here, and then I'll put the two of you into a breakout room.
Thank you, Your Honor.
So there was this little part that Mr. Rolla's audio was so badly garbled, and I did transcribe it for you guys. But what was stated there was that if they went through with this motion, then the plea offer was off the table. And so they're going through with that motion, and yeah, we'll see how that goes for them. Let's see. Oh, I can put us both at the bottom there. There we go.
All right, and then I did have a question for counsel. We have Mr. Papp scheduled at 9:30, and then later this afternoon. Do we know when? I don't believe Department of Corrections has brought him here yet this morning. What was your understanding?
Well, there's two different files too.
Right.
I guess I don't have an answer to that because I didn't realize there were two different files.
Yeah. Okay. All right. So you were prepared to go forward at 9:30 and later this afternoon?
And unfortunately, I'm in front of Judge Hesslink this afternoon.
Judge, with all deference to Mr. Truce, I believe it's a different counsel.
Oh, it is. That's right. Okay.
That's the state appellate defender's office.
Okay.
So Richard, you're off the hook.
All right.
My heart rate can slow down a little bit.
You handled it really well. You didn't look panicky.
Just pale.
You're good under pressure. I'll say that. Okay. All right. Were you anticipating Mr. Papp being here this morning for your motion?
I mean, given the nature of the case, I would prefer he see the motion.
Okay.
I don't think he's going to actually participate in it, but he has been active in the case.
And they may be connecting him right now, actually. So.
There was a red done, Judge, so I can confirm that part.
Let's see if this is Mr. Papp. Oh, that is, okay. Mr. Papp, are you able to hear me okay?
Yes, sir.
Okay. Are you ready to proceed, Mr. Truce? We're a little bit ahead of schedule, but you're ready to go.
Yes, Your Honor.
Okay. All right, we'll go on the record in People versus Carl Papp. This is file number 256857. The record should reflect that Mr. Papp is present today by Zoom video from Department of Corrections.
I had to try something. Dang it. Why won't this work? on. Give me 2 seconds. 2 seconds. I promise. I promise. There we go. There. All right. I just had to edit this a little bit so that the kitty tower was on the top.
Yeah, council appearances on.
For the record, Your Honor, I call back people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Pat.
Mr. Trush, this is your motion to quash. I did have a chance to review your motion, and I understand, you know, your argument is that there wasn't sufficient evidence presented at the preliminary examination for a court to find that there's probable cause to believe that the alleged crime occurred in Otsego County. And so it's kind of a venue jurisdictional challenge to the court proceeding and the bind over. Is that a fair statement?
Yes, Your Honor, and having reviewed the prosecutor's response, I think largely we agree as to sort of the factual underpinnings of it. At the preliminary exam, there were two people who testified in essentially the extent of their testimony was that Mr. Papp lived in Otsego County at the time that this conception is believed to have happened. And I think that's about the extent of it. I mean, I think they tried to and wanted to get further than that, but there isn't. The alleged victim did testify. Ultimately, her testimony was stricken as, you know, she asserted her Fifth Amendment right and then didn't, and then did, and we kind of got to an impasse where there was, I think, one question that she refused to answer or did not want to answer, and everything, all the testimony was stricken. Even in that, I mean, there's nothing to establish where the event took place if it did. Now, the two things I guess I want to point out to the court, in the prosecutor's responsive brief, he put the venue jury instruction in. And I think it's valuable and helpful. There is a special jury instruction for criminal sexual conduct cases, and it indicates they don't have to prove a time and they don't have to prove a date necessarily. But what's important is they do still have to prove a location. And again, in this case, other than that he lived in this county, there's not anything to establish that. And I mean, I say that because, I mean, to look at this in the context of any number of other cases, how many people from outside of the county come into the county and potentially commit crimes? I mean, I imagine if the court were to look at its docket today, at least half of the docket, I'm sure, is people who are committing crimes outside of their home county. So, I mean, fundamentally, I think there's an issue here. I don't think there's enough for a bind over. And you know, I mean, certainly if the motion is denied here, I mean, this is going to be an issue for trial. That's for sure.
Well, and it certainly could be an issue for trial because there's a vastly different standard that would be applied at trial. But isn't there more than just Mr. Papp was living here at the time though, right? I mean, we have the alleged victim had a child that I don't think there's a factual dispute that Mr. Papp is father of that child. So we have more than him just living in the county. We have him living in the county at the time, and by backwards calculation, or forwards calculation, we have a child that he fathered. that would have had to been conceived about the time that he was living in Otsego County. So isn't that an additional fact that we have here?
I mean, without conceding that,
Yeah,
that may be
I
a challenged
understand.
issue at a trial, but accepting that for purposes of this hearing, I mean, even if we accept that he fathered a child and he was living in Otsego County, does not mean that that act occurred within this county.
No, I agree with you, but it's a fact that if a jury were to believe those things could conclude or could find that the act that led to that child occurred in Otsego County based on the timing.
I don't know that I would agree. I mean, I guess I can't suppose what a jury would or wouldn't rely on.
No.
It certainly doesn't necessarily follow.
Okay, thank you. Mr. Rowland.
Yes, thank you, Judge. A couple of things. First off,
Mr. Papp, did you need to talk to your lawyer?
Yeah, if I could give it 2 seconds.
Do you want to sign in so you can speak to Mr. Papp?
I can do that.
That's up to you. If
Yeah,
you wanna-
Or am I-
Mr. Papp, is
Or
it
if I
something
could
you need to
just-
talk? Hold on, let me
There's
talk.
something I
Is it-
could say, there was testimony on top of that, I was just gonna let you know.
No, I definitely don't want you to say anything. Let me
Okay.
log in and we can talk in a breakout room. If it's something that we need to say, I would say.
All right. Mr. Papp, I'm gonna put you into a breakout room with your lawyer, okay? So you can talk to him privately.
Yes, Your Honor.
Okay, Mr. Trush, I'm gonna put you into that breakout room right now. Okay, Mr. Papp, I think Mr. Trush should be heading back in here.
Yes, Your Honor.
Okay, we'll go back on the record in People versus Papp. Mr. Trush, did you have an opportunity to speak with Mr. Papp?
I did, and he had just reminded me and wanted me to remind the court. There was testimony at the preliminary exam about his work. There was testimony that, his work took him basically all over the state. And there was testimony from, again, the alleged victim's testimony was stricken, but testimony from both her and from the Britta, that the alleged victim would frequently travel with him.
You really want to use that argument? Because last time I checked, taking a minor across state lines for those types of activities got a much bigger penalty than what he's currently facing. You really want to go there? What a dummy.
All over the state. So again, I think that is important to the context of there's really very little to connect this event to occurring in this county.
All right, thank you, Mr. Rollins.
contrary, on a couple of things. First and foremost, even at a best case scenario, this motion is premature because, again, the venue issue is an issue to be decided, question of fact to the jury. That would be the point in time for that motion. But we don't need, people don't even think we need to get there for a whole bunch of reasons. Mr. Trush has repeatedly mentioned the testimony of the victim and it being stricken. And what he's left out is the victim indicated that she got pregnant in the residence that she was residing with the defendant. Further, as indicated in our brief, the venue is an issue that's not an element of the crime. There's also additional evidence, not just that Mr. Papp was residing in that residence and the minor victim was under his care at the time she gave, just prior to giving birth, because she was obviously in the hospital when she gives birth. But she was under his care and in that residence and residing with him at the time she became pregnant and well before she became pregnant. Now, it wasn't brought up at the preliminary examination, but, and I was gonna attach this as to our brief, but I will just advise the court of it. Mr. Papp, as a registered sex offender, has to file a statement under oath in regards to where he's residing and how long he's residing there.
So he was already a registered sex offender. Already. In fact, I believe it's habitual fourth.
And I'll be happy to provide this document to the court, but I'll just indicate to the court, it indicates that his residence was the one in Vanderbilt, in Otsego, on North Old 27, Gaylord, Michigan, and he had been residing there since at least April of 2023. In any case, it's not, as the court indicated, moving the time back to show that that's how she came or the time she became pregnant. It's also the fact that they were residing there, that in fact, that they were residing there all together, that Mr. Papp was in control of the minor at the time she became pregnant. And quite frankly, even if argue is speaking, that, and as I pointed out in my brief, even if you could argue that, well, maybe they actually had sex in some other counties at some time too, it's unlikely that the victim got pregnant after only one single episode. But she got pregnant after residing with the defendant in the residence in Otsego County. And there's more than substantial evidence, more than a preponderance of the evidence that that's where pregnancy occurred. I think it's reasonable trial effect as well, since that's really where this motion should be brought. So it's premature at this time, would be able to find beyond a reasonable doubt that in fact, that's where she became pregnant. In addition, as the court's aware, and as is pointed out to Mr. Truce, there's a reason for that jury instruction being written the way it is with minor victims. The prosecution does not have to prove exactly the date and time she became pregnant. Because again, as I've already indicated, it's unlikely that this occurred from only a single episode, which is why the offense code in this particular case and the information says on or about March of 2023. For all of those reasons, Your Honor, we feel the motion to quash the bind over should be denied. Thank you.
Mr. Truce, any response?
So, I mean, a few things. I mean, much of the prosecutor's argument here makes an assumption that I think we all know is not accurate. And the assumption seems to be that sex only happens now. It's not accurate. I mean, if it was, I think the hotel industry would probably just collapse on itself. I mean, it's not accurate. I mean, we know that it could happen in any number of different places.
Again, not good arguments.
In addition to that, I agree with him insofar as the jury instruction, but I think he's misplacing where that is. And I mean, part of it is the ultimate underlying issue with this case, but I mean, it comes to a head with this venue issue here. He's right. He doesn't have to prove an exact time and date. He does have to prove an incident occurred. In this case, because of the conception, I think he probably has proofs to prove an incident occurred. Probably. Fundamentally, though, I mean, the issue is the alleged victim has not testified that anything occurred. And again, I mean, understanding that her testimony was stricken, I mean, her statements have never been that anything occurred. Now, I recognize the prosecutor thinks that what she's saying is dishonest, and he's entitled to his opinion, and whatever happens in a trial will happen. But fundamentally, whether she's going to testify that something happened or didn't, the burden of proving the event is on him. And I mean, if he's going to say, well, probably didn't happen from one event, he's got to be able to prove that more than one event happened. I mean, we all know it could happen from one event. Certainly could. Again, do I tend to agree? It may not be probable. But I mean, the fundamental issue that he's gonna have to grapple with is what is his testimony from his victim gonna be? I mean, if he wants to argue that there was a series of events, he needs something to support that. Or I mean, I guess he can argue without that, but I mean, it's problems for him. If he wants to argue that it happened here because that's where he lived, I mean, again, he needs something to support it. And if his victim is not saying that, or potentially, if his victim comes in and says, yeah, you know, this happened one time in Sheboygan County, it's a problem.
All right, yeah, that may very well happen. I don't know what would happen at trial. But I've got to look at this in the context of the motion that's before the court, which is a motion to quash based on the bind over and the evidence that was presented at the preliminary exam for the district court to conclude that there was sufficient evidence that this crime occurred within Otsego County to bind it over to my court. And so the court's reviewing this as a motion to quash the bind over, which is how it's styled. And I think regardless of how it's titled or styled, that is the basis of it. So I'm looking at district court's decision and was there sufficient evidence for the district court to conclude that under a probable cause standard to bind it over. When the court is reviewing those kind of decisions by the district court, the court reviews for an abuse of discretion. So we have two things kind of at play here. Number one, we have a low standard of only probable cause, and then we have my standard of review of that decision, which is abuse of discretion. It's not a de novo review, so it's not what I think or my view of the evidence is. Was the district court's decision to bind over within the range of reasonable and principled outcomes, recognizing that a different court may come up with a different decision. So what that means for the purposes of this motion is this court would find a glaring error by the district court in order to quash the bind over in this case. So was the district court's decision within the range of reasonable and principled outcomes such that it was not an abuse of discretion? So we don't have any direct evidence that I could find that this crime occurred within Otsego County, but there certainly is circumstantial evidence, and as counsel is aware, and as part of the jury instructions, circumstantial evidence by itself or a combination of it and direct evidence can be used to prove the elements of a crime. And so the court could use circumstantial evidence to find probable cause that this occurred in Otsego County. So what circumstantial evidence do we have? We have some evidence that the victim, alleged victim, became pregnant and had a child. There's some evidence that the defendant is the father of that child. Based on when that child was born, there's evidence that that conception could have occurred at a time when both the defendant and the victim were present in Otsego County. And so does that evidence meet the standard of probable cause? And that is, would a reasonably prudent person be able to conclude from that evidence that this crime occurred within Otsego County? And I think it's not an abuse of discretion for the district court to have found that a reasonably prudent person could conclude from that circumstantial evidence that this crime occurred within Otsego County. So because I can't find that there's an abuse of discretion in that determination by the district court based on that evidence, the court will deny quash. Certainly, there's a different standard at trial. This may be the subject of a directed verdict, depending on what the prosecutor is able to show evidence at trial. But again, under probable standard and abuse of discretion standard, this court must deny the motion. So Mr. Church, if you would prepare an order that reflects that ruling, and the court will sign that. We do have this set for a scheduling conference. I'm assuming that we want to get this on the trial calendar. Mr. Church.
Yes, I would like to go to the trial.
Okay, Mr. Rolla, how many days of trial do you think this will take?
I'm gonna indicate, in light of the number of witnesses, probably 3 or 4 days, Judge.
Okay, Mr. Truce.
And I say that based upon a previous trial where we're gonna have the flip scenario because under 768-27B, evidence of the defendant's other prior matter might be able to come in. I don't know. We'll see on that.
I would assume probably about a half day for defense proofs.
Okay, so if we set it for 4 days, do you think that would be enough?
I think that would probably be sufficient.
Okay.
And keeping in mind, obviously, the prosecutor seems to have indicated that he may be filing a notice of other acts notice. I don't want to presume at this point what that's going to look like.
Sure. Mr. Bola, how far out do you want the court to set this trial?
Well, Judge, I think it's gonna actually be a scheduling issue for the court, it's gonna be from my office now. So I will leave that to the court's availability for a 4-day date time period.
So whenever we can get a date, you can be ready.
Please no less than 60 days, but
Okay,
other than that, yes, Judge, I think that's appropriate. Thank you.
Mr. Truce.
I think 60 days would be fine with final status conference to proceed it. I would indicate there is some DNA issues that we're looking into. I don't know if it's going to materialize or into anything or not, but I mean, I do want to make sure we have time to explore that issue fully. I would request that Mr. Papp be transported in person for the final status conference if we could.
Okay.
I am able to schedule meetings with him. They're semi-private at best, and it does affect our ability to communicate.
Yeah, so if you can just communicate with the prosecutor and make sure it's an in-person writ, I have no problem.
I've already put a note to that effect in the file, Judge.
Okay. All right, so we'll set this for a 4-day jury trial. I will set it for a final status conference on the motion day prior to the trial date. That will be the plea cutoff. To the extent that either side has motions, they would need to be filed and set for hearing no later than the date of that final status conference. Mr. Rolla, anything else that I can address for your
Thank you, Judge.
Mr. Church?
Nothing further.
Okay. All right, Mr. Papp, that's all for this case today, and we're going to disconnect at this time.
All right, thank you.
Mr. Papp, are you able to hear me okay?
Yes, Your Honor.
Okay, we've got a little bit of feedback coming from your end, so I'm just going to mute yours. Ms. McCann, can you unmute, please?
Yes, good afternoon, Your Honor.
All right, good afternoon. So we're on the record now in People versus Papp. This is file number 236564. The record should reflect Mr. Papp is present today by video from Department of Corrections. We have Ms. McCann on behalf of Mr. Papp here present by Zoom video. Mr. Roll is present here in the courtroom. This is a motion for a Ginther hearing or to grant a new trial. I've had a chance to review the motion and the arguments supporting that, as well as the case law cited by Mr. Papp and his counsel. Mr. Roll, I did receive your response, and I had an opportunity to review that as well. Ms. McCann, anything by way of oral argument that you wanted to present here today?
Just briefly, Your Honor, in light of the court's comments. And again, for the record, my name is Jacqueline McCann. I'm here on behalf of Mr. Papp, and he is appearing by Zoom with our consent. Your Honor, this was really a question of constructive possession. And we believe that the errors that we outlined in issue 1, particularly as to not calling Ms. Daniels, left that an unfair contest for Mr. Papp, that he wasn't able to show the jury that he was not in constructive possession of the weapon. And we've emphasized in our brief that this case is distinguishable from our Supreme Court's case in People versus Bergenmeyer, because in that situation, the gun was in an area of general control and it was not locked up. And so we don't have that here. We have very specific precautions taken by Miss Daniels, so that the gun was not available or able to be controlled by Mr. Papp when he was home. And that should have been a jury question. And so we do ask the court either to grant this motion or to grant an evidentiary hearing in regards to the ineffective assistance of counsel issue. We did acknowledge in our brief, Your Honor, as I'm sure you saw, that our remaining two issues are more law reform issues that we're preserving here and hope to get a favorable ruling in the appellate courts on those.
Sure. I did have a question on one of those arguments, though, just for clarification on my part.
Sure.
The argument regarding the Second Amendment, is that argument go towards Miss Daniels or anyone else who might want to reside with Mr. Papp, an infringement on their ability to possess firearms because he can't be in a home where those are, so presumably they
So, the house that he was living in, he was essentially in a relationship with the girl's mother, acting as stepdaddy to the girl. There was a firearm owned by the girl's mom. Why she didn't use it on him, I will never know. And yeah, as far as the motion for a new trial, it's not the trial that is currently ongoing or just recently concluded. He was a fourth habitual offender. So he's trying to get a motion for a new trial on one of his other cases against minors. This guy is a piece of work or a piece of something.
they're restricted from exercising their rights under the Second Amendment, or is it more from Mr. Papp's point of view, where he's prevented from living with people who have the right to lawful gun ownership? I just wanted some clarification on that.
I don't think that it has to be one or the other, Your Honor. The as you pointed out, the rights of Ms. Daniels to live in a home protected by a firearm, I think, can be asserted in Mr. Papp's appeal in the same way that, say, a Batson issue, where the defendant gets to assert the jurors' rights, and then separately that Mr. Papp has his own Second Amendment rights and other constitutional rights not to be prevented from living in a home and cohabitating with somebody who has a firearm.
Okay, all right, thank you, Mr. Rolla.
Yeah, briefly, Judge, we'll deal with that last item first. Our Michigan courts have already ruled on this issue. In fact, as I indicated in my brief, those decisions are binding upon this court. The decisions cited by the other side, I understand they want a change in the law, but again, that's not the decision for this court to make. I understand they're preserving it for the record, and that's fine, but that doesn't affect, quite frankly, this court's decision. And I apologize, Your Honor, for bringing back what I'm sure is probably a clear and painful memory for the court.
This is wild.
And again, appellate counsel is at a disadvantage because they were not present at Mr. Papp's jury trial as you and I were when the issue came up regarding the alleged weapon having a trigger lock in it and not being accessible to Mr. Papp. As the court, I'm sure, will recall, and as I cited in my brief between pages, I believe, 119 at line 14 and 123, line 16 or 17, it's a situation where, although there was a trigger lock, device attached to the weapon in question. When Deputy Steve Singer was on the witness stand, he testified, as did other people, that that trigger lock device, because it had been improperly installed, did not prevent the weapon from being fired. And I'm sure the court will recall the instances when Deputy Singer was examining said weapon, which was marked as an exhibit for the people, that the weapon was dropped and we had live ammunition bouncing around the courtroom floor in front of the jury. I distinctively recall the court's physical response at that time. I've since had an opportunity, obviously, of course, to go back and look at the video of that, and it's unfortunate that it occurred, but the whole point is that that weapon, as testified to by numerous witnesses in the prosecution's case, was not locked up. It was sitting on top in the master bedroom that the defendant shared with the actual gun owner, and it had a trigger lock device that did not prevent the weapon from being fired, as was testified to and demonstrated to by Deputy Singer. The arguments to the contrary are factually inaccurate and legally distinguishable as laid out in the people's brief. The motion should be denied. Thank you, Your Honor.
All right, thank you. Ms. McCann, it's your motion. I'll give you the last word. Any response that you wanted to make?
Well, Your Honor, I believe that the statutes also involve an intent element. They're not strict liability. And so while I respect the prosecutor's arguments in that regard, I think they don't foreclose relief. And beyond that, I would rely on the briefs.
All right, thank you. So again, I did have a chance to review the briefs. The arguments of counsel of both sides here today on the record have been consistent with their arguments that they set forth in writing. In my view, the defendant raises 5 different potential bases here. The first 3 all involve ineffective assistance of counsel. And so in order for the court to find that there was ineffective assistance of counsel or to order an evidentiary hearing into that, the court has to have a basis to find, first of all, that trial counsel's performance was below an objective standard of reasonableness under professional norms, and that there's a reasonable probability that if not for those errors, the result would have been different. And the result that did occur was fundamentally unfair or unreliable. Effective assistance of counsel is presumed, and the defendant bears the burden of showing that the trial counsel was ineffective. In terms of matters of trial strategy, the court is not to substitute its judgment for that of counsel, or to, for lack of a better term, Monday morning quarterback strategic decisions made by a trial counsel. And so the court has to give a great degree of deference to that, including the decisions of whether or not to call witnesses in particular are matters of trial strategy generally that shouldn't be second guessed by courts unless, again, they're clearly result in an ineffective assistance. So the first basis, of course, is the failure to call Ms. Daniels to testify. And certainly she could have testified to some of the things raised by defendant in their brief. However, I think it was clear from the testimony of this incident in general and Ms. Daniels' own record that she's an individual that's highly excitable. And I think the officers in this case all testified that she was very difficult to deal with. And I think that's kind of a fact that's generally known. And so I think it's well within trial counsel's view that Ms. Daniels, while she could have provided some helpful testimony, that her demeanor, her behavior and so forth in court or on the witness stand could certainly have been negative to the point that it hurt Mr. Papp's case. And so I think the fact that trial counsel chose not to call her was a reasonable decision given Ms. Daniels' behavior. So I think it's very possible that trial counsel very reasonably could have concluded that while she could have provided some helpful testimony that overall her presence in court or her demeanor on the witness stand would have given an overall negative effect to the case. So again, the court finds that as a matter of trial strategy, that was not ineffective assistance. The second was the failure to file a motion to suppress due to a warrantless search in this case. There's a lot of argument about the basis of the search and whether the officers would have had a reasonable basis. I think for officer safety, certainly under the circumstances as it was presented to them at the time, with two individuals who were acting out and presenting a danger to the officers, I think a search of the residence for officer safety certainly could be justified. I think more than that, the officers were there to undertake an eviction. The officers were there to remove all the personal property from the home. I think the inevitable discovery doctrine would apply here, regardless of whether there was a warrant or not a warrant, regardless of whether the officers had a basis to conduct a warrantless search for their safety. I think that's an item that would have been discovered regardless, because they were there to do an eviction. They were there to remove all the personal property. That weapon would have been found as part of the eviction process. And so again, the court finds that the inevitable discovery doctrine would apply. Regardless, I think there's enough basis for trial counsel to conclude that a motion to suppress wouldn't have been successful and wasn't warranted. And so I don't find that that decision fell below an objective standard of reasonableness. Finally, the failure to object to admission of evidence of Mr. Papp's criminal record in light of a stipulation that he was a felon who was unable to possess a firearm at that time. While trial counsel certainly didn't use the word objection, trial counsel certainly pointed out reasons why the court shouldn't admit it, and then left it up to the court's discretion. So trial counsel did raise those issues, did point out to the court why the court would have a basis not to admit it. The court admitted that evidence anyway, so I think my decision to admit that certainly is something that could be challenged on appeal, but I don't think it demonstrates ineffective assistance of trial counsel, because trial counsel did raise the problems with admitting that, and the court nonetheless admitted it over those. Again, he didn't phrase it as an objection, but clearly he was pointing out reasons why it shouldn't be admitted. So the court finds that in terms of the arguments for ineffective assistance, there isn't sufficient showing that the court should order a Ginther hearing, or that there was ineffective assistance of counsel. So motion for an evidentiary hearing or new trial on that basis is denied. The fourth basis was the violation of Second Amendment rights. Number one, courts are to construe statutes in a way that would lead to a finding of constitutionality. Aside from that, however, in this case, I find that if there's any kind of constitutional challenge, it would be to some kind of constitutional right of association, not necessarily a right of possession of firearms, because as it relates to Ms. Daniels, she still has the right to use and possess firearms if she otherwise legally can. The only thing that's preventing her from doing that is her decision to reside with somebody who can't be around firearms. So number one, in my view, it's kind of a waiver of her Second Amendment rights to the extent they're implicated. And number two, the real effect it has is preventing her from living with those individuals, not from preventing her from exercising her Second Amendment rights.
I absolutely love how the judge put that. And here's the thing. yes, it's bonkers, but it was perfect. Thank goodness, from the sounds of it, nobody got injured. But the argument of the defense was that it's okay that there was a pew pew in the home and he shouldn't be found, he shouldn't be found guilty or violated for that because it had a trigger lock on it. Well, and he wasn't able to discharge it with the trigger lock on it. Well, the officer sure proved them wrong accidentally when he fumbled it. The pew pew hit the ground, and there was live ammunition bouncing from the walls of the courtroom. And I have no idea why it was loaded in the first place. I have no idea, trigger lock or not. I'm pretty sure that's a big no-no.
And in addition, she's not prevented from having those firearms. She's only prevented from having them in a place where the defendant would know where they're at and would have reasonable access to them. So it doesn't even fully implicate her ability to possess firearms. And the same thing goes as applied to the defendant. So the court denies the motion on that basis. And then finally, the argument regarding the operability or inoperability of the weapon, the court finds that Peels is a binding precedent. As a trial court, I'm not in a position to ignore binding precedent because I disagree with it or because the trial court feels that it's improperly decided, which is what the defendant is asking me to do, quite literally in their brief. So the court will decline to overrule established binding precedent. So for all those reasons, the court denies the motion for evidentiary hearing and new trial. Ms. McCann, I would just ask that you prepare an order and submit that under the 7-day rule or with a stipulation as to form from opposing counsel.
Certainly, Your Honor.
Ms. McCann, is there anything further from your side today?
Just a housekeeping note, Your Honor, under 7.208, I think it says that a transcript of today's proceedings, I think it should be filed within 28 days. We will contact the normal people that we would contact for Your Honor's county to order that.
Okay, thank you. Mr. Roll, anything?
Yeah, Judge, for benefit of Ms. McCann, our office has a policy on the order. If you want to make a copy of it, attach it to an email sent to our office, you can do that. I'll review it quickly and then give you permission to sign.
Thank you. We'll get that out the next day or so.
Very good.
Your Honor, may I address Mr. Papp just briefly to let him know that I will be in touch with him as to our next steps.
Okay. All right, very good. Thank you. That's all for this hearing today.
Thank you.
All parties are free to disconnect. Mr. Trush, were you anticipating Mr. Papp connecting today?
I mean, I would hope so. He is next door at the county jail. And frankly, I think that he intends to tender a plea to the original offer the prosecutor made today, if that's still on the table.
It's not.
Okay. All right, hold on. Let me, Leanne, can you call over to the jail? I didn't realize Mr. Papp was here. I thought he was still in Department of Corrections. Mr. Trush, rather than, I'd like to put you and Mr. Rolla into a breakout room so that you can talk about the plea off the record and not in front of the court, okay? Mr. Roll, are you there?
Yes, Judge.
Okay. I don't know if your camera's off. I can't see.
Oh,
you,
I'm
but
sorry.
That's okay. I just want to
It's
make
not,
sure that.
there we go. Now okay, I'm back again.
Gotcha. Okay.
Actually,
So
I
I'm
logged
just gonna
in
put,
about 22, Judge. Thank you.
okay. I'm gonna put you and Mr. Trush into a breakout room while we're waiting to get Mr. Pap connected.
Very good. Thank you.
Judge, they're gonna get him on Zoom.
Okay, thank you. Mr. Pap, are you able to hear me okay? You guys able to hear me at the jail there?
Yes, sir.
Okay. The lawyers are talking in a breakout room, so it'll just be a second.
Yes, sir. Mr. Trush, you want? Oh, sorry.
Okay, Mr. Trush, did you need to talk to Mr. Pap?
No. So, Your Honor, having talked to the prosecutor, I think we're going to ask the court to do a couple things today. So one, we are going to ask the court to make a ruling on the motion. And frankly, I think it's more for the purposes of directing us how to proceed in future, because for both of us, I mean, this has some pretty significant implications in terms of how we conduct business in the future. Mr. Rolla indicated that he wanted to talk to the victim. So at this junction, I would say I anticipate that we'll have a plea at the hearing next week. I think we're set for Wednesday of next week. I anticipate we'll have a plea then, but he wants to discuss it with the victim. Additionally, there was a new interview done with the victim. I've seen the officer's his report of what it is, but not the video. So I do think I probably need to lay eyes on that as well.
Okay. Mr. Roll, is that accurate?
It is, Judge, and I'd also add additionally, Mr. Trush's office very recently received additional reports, specifically regarding to another witness, Miss Britta Daniels, and the video interview on that. I know he's gone over the report synopsis. I don't know if he's gone through the entire video yet. He hadn't when I spoke to him last Friday. So there's two of those. And in any case, I would indicate we did make an offer. There was some request to change that offer. We've had those discussions. Defense counsel knows what it is, and it would be the people's position that this matter be scheduled for a plea next Wednesday. I anticipate that's going to take place. But again, I do want to speak to the victim in light of the severe nature of the matters before I do that.
Okay. All right. So in terms of the motion, it's defendant's motion to disqualify the prosecutor and to suppress certain communications. I had a chance to review your motion, Mr. Trush, along with the cases that you attached to that. Mr. Roll, I did get your response. I had a chance to review that. I guess one of the questions I had and needed clarifying by either of you is just an offer of proof, because there weren't any of the actual communications attached. There wasn't a lot of factual background about when and how those communications were made and the content of those. So Mr. Trush, or Mr. Rolla, I'm just looking for an offer of proof as to, kind of a little bit more of the details of these messages. Mr. Trush, did you want to address that at your motion first, I guess?
So I can, and Your Honor, I was kind of in new territory here in terms of my worry was if I provide the content of the messages, or if I provide them to the court, my worry is now I'm creating an additional layer of taint that I have to address. What I would indicate in terms of the content of the messages, Mr. Pap and I, there, by my count, were 40 or so JPay emails that were between Mr. Pap and myself that were ultimately recovered. Those emails discussed a variety of things in the case, from really starting with how we're going to approach the preliminary exam, to different evidentiary issues, different potential motions we might file. So, from my perspective, we discussed essential elements of the case that certainly would touch on defense strategy. At a fundamental level, though, I mean, content set aside, which I understand why the court is concerned with that. I mean, the primary concern that I have is, the prosecutor basically having any of my communications with the client to me is concerning. Some of the emails probably don't touch to, strategy, but some of them certainly do.
Okay, all right, that answers that question. Mr. Rolla, then I have a question for you. I mean, is this something that your office regularly does, is get JPay messages and review them? How did you happen to do that in this case, if it's not a normal practice? This just seems like, I just need more information from your side about how you got these messages and why.
And this is another one of those layers and elements that I was talking about why this whole string of cases became so fascinating to me. They reference JPay messages, and those are basically inmate emails and inmate text messages. So when someone's locked up, they can put money on their books and they can spend, 50 cents to $1.50 to send a text message, or, a couple dollars to send an email, rather than having to pay the $5 per minute for the phone calls. So when they're referencing JPay, that's what that is.
Very good, Judge, and perhaps a little foundation. I can't comment on the content of any of the emails, JPay messages, however you want to call them. Any of the ones that may have had Mr. Trush's office his name on it, or communications. As soon as we saw that those were in there, I put in a firewall scenario similar to what was done in Amerson. And I immediately notified law enforcement that don't open them, don't view them, don't read them. I don't want to know about them. So I have no idea what content they may or may not contain, nor does anybody else in my office. And to more directly answer the court's question, this was a very unique scenario. As the court is well aware, and as I put in my brief under the holding in Campo, or Pearson dealt with communications to third parties. Campo dealt with where there's a lack of confidentiality. What had happened and the way these came to the people's attention, and I apologize if it wasn't clear in my brief, but to put it simply as an offer of proof, you had a situation where some emails were sent to the victim in this case, that the victim's boyfriend saw them on her phone. The victim's boyfriend brought those to the attention of Child Protective Services worker, Miss Bobra Johnson, the supervisor, apparently during just a regular home visit, home check. I don't know exactly. I obviously wasn't there. And those messages then were, because of the content of those messages, and to be clear, these are not attorney-client messages. These were messages sent to and received from the defendant and the victim in this particular matter, in the people's opinion, violation of the order of pretrial release. But in any case, because of the content of those, they were then brought to law enforcement's attention. That's how those copies were made. After those were made, then it was found that there were additional JPay messages that apparently had been going back and forth since February of this year through October of this year, and pursuant to the JPay user requirements, which indicate that upon request, they're sent to any law enforcement agency. A request was made about JPay messages. The Department of Corrections, as I understand it, then sent them to the Michigan State Police. But again, there's a big division between communications sent to third parties, specifically involving those going to and from Britta Daniels and to and from the victim with the defendant. Those are the ones that people would be intending to use were the matter to go to trial. If that answers the court's question.
Okay, I think so. Just so your office didn't request those records, and that was something that came to the attention of law enforcement from a third party, and then when you started looking into those messages, or the police, you saw that some of them involved communications between Mr. Trush and Mr. Papp, and those were
Allegedly,
not.
Judge, I know they were sent. I don't know what the content was.
Right, but you didn't go in there trying to get those, and you didn't view those or record those in any way.
Correct, Your Honor. In fact, we took steps to specifically not have that happen, to avoid even an appearance of interfering with the attorney-client relationship. We just put a block on them and said, no, don't look at them. We don't want them. And in fact, the investigating officer in this case and I had quite the discussion, because it was, well, we don't care what those messages say. We're not interested in those anyway. We're only interested in the ones that went between the defendant and the victim, or the defendant and the victim's mother.
Okay. All right. Thank you. So that clarifies the kind of the background and factual questions I had. Then Mr. Trush, with regard to legal argument, was there anything that you wanted to add in addition to what's in your brief?
Just very briefly. So, there were a handful of cases that were cited by myself and the prosecutor, and I think actually we cited some of the same cases because it kind of outlines the test. I think there's a distinction between some of the cases that the prosecutor cited and the case sort of as we have it presented here. And I think the most similar case to what we have here, while it's not a perfect match, is Jolly. And in that case, I think it's different because in one of the cases the prosecutor cited, I mean, the real issue that the court took up was whether or not the communication is protected because it was essentially planning a crime, right? And obviously that's not a protected communication, right? I mean, that can't be a protected communication. In Emerson, we have a similar situation where the communication I don't think is protected because it's not direct attorney-client communication. What we have is communications from the attorney to an expert who's then later consulted by the prosecution, independent. And I think it's slightly different because the expert ultimately wasn't hired by defense, and it seems pretty clear at least that the defense expert, I don't think, gave there wasn't any disclosure of information other than he disclosed, hey, defense consulted with me and they stopped. The case here, though, I think is more close to Jolly, where you're looking at actual communications between the attorney and the client, not sort of tangential communication, but direct communication. And the analogy is pretty strong because in Jolly, it's an email, right? It's an email between the attorney and the client where the client talks about where some things essentially have gone, what he did with them. Based on that, then they get a search warrant and go and get those things. So I think it's more analogous to that. So again, and I guess what I would say here, I mean, I certainly don't dispute what the prosecutor is saying in terms of the steps that he took to try to prevent, any of the information from getting out. But what it doesn't change is the fact that there's a PDF that was produced to the state police. Again, at least on information and belief, went to the prosecutor's office and then was sent to me in discovery, which has, again, a PDF version, a printout of, 40 or so of my emails to my client. Granted, I agree with the prosecutor that the format it's in, if you don't zoom in, you can't read what they are. But I mean, it doesn't change the fact that exists out there now.
Okay. All right. Thank you. Mr. Rolla?
Yeah, thank you, Judge. I agree. Jolly sets out the factors that you have to look at. However, in Jolly, the court only dealt with the suppression situation. They did not deal with a disqualification situation, which is specifically why I cited Emerson. Going back to Jolly, however, though, the biggest distinction between that and this case is in Jolly, once the police became aware that they had attorney-client information, the original email, they took that original email and then they used it to gain additional investigative information in the arson case to find the gas can, the lawnmower, some other matters as well. So they doubled down on screwing up. In other words, they twice did what they shouldn't have done, as opposed to the circumstance in our case and in Emerson, where once it looked like this could be a problem, specific steps were taken to avoid any intentional intrusion much into the attorney-client relationship, much less any substantial prejudice to the defendant. In Emerson, as Mr. Trush indicated, you had the circumstance that, well, once the prosecution found out that this other person who they were going to had listed as a witness and were going to call for trial, had in fact been previously interviewed by the defense, they said, nope, we're taking you off the witness list. We're not going to do that. Went and got another witness, expert witness. In our particular case, once an email indicated that it had defense counsel or his office name on it as being a sending or receiving party, even without looking at the content, steps were immediately made not to look into that further. So where the warning signs came up that were not followed in Jolly, but were followed in Emerson, so was done in this particular case. It's a situation where we're not looking at it. We don't think it's appropriate to be looked at. It may or may not even be relevant. I don't even know. We don't know what the content is, but in any case, people were willing to stipulate that we're not using that, as I indicated in our brief. So it's a situation where actually Jolly, which, like I said, only dealt with suppression, as was noted in Emerson, Jolly did not deal with at all a disqualification of the prosecutor's office because there was no intentional intrusion into the attorney-client relationship, much less any substantial prejudice caused by that. Therefore, there's no due process violation. Therefore, there's no disqualification.
Okay, thank you. Mr. Trush, it's your motion. Anything you wanted to say in response?
So a few things. I mean, I think the real value of Emerson to us here is it's not that it's perfectly analogous, because it's not, but I think what that brings to the table or directs us is that the same process, the same test outlined in Jolly is what you would apply if disqualification is sought. I think that's the value of that case in terms of how it applies to this scenario. And I guess the other thing that I would just indicate to the court is, I mean, obviously this is a difficult scenario, and from a public policy standpoint, right? I mean, I need to be able to have communications with a client who is incarcerated. I mean, that just has to happen. If it doesn't, how do we process cases? I mean, we can't move things forward. If I can't rely on JPays, if I can't rely on video visits and phone calls, because again, many of those things I can't confirm when I call in that they're not being recorded. And sometimes I know they're only semi-private. If I can't rely on those, I mean, effectively, I'm going to be limited to having to travel to a correctional facility before every hearing. And I don't say this because, I don't want to, do the work, but I say it because every time you put a barrier between that communication, you have the effect of chilling it, right? You have the effect of making it harder. When we make it harder, one of a few things happens, right? And I mean, one, either the communication doesn't occur, which isn't good, doesn't serve interests, or what we do is we make the communication significantly more expensive. And at least in this case, I mean, that means to the taxpayers, right? I mean, if I have to drive to Newberry every time I have to talk to Mr. Papp, the court's effectively going to pay me essentially for a day of trial every time I talk to him. It's not a good use of the taxpayer dollars. And that's partially why, there's three different pieces of relief that I have asked the court to consider. One obviously is suppression of the evidence. The second is, to instruct that those types of communications go through a taint team. And in the context of the prosecutor's office in Otsego, it could be as simple as, his APA reviews it before it goes to him, right? Because conflicts aren't imputed up in a prosecutor's office, they're imputed down. Meaning, because the APA, Mr. Rolla doesn't inherit all of his conflicts the way that the APA inherits all of Mr. Rolla's. So again, I think there's some compelling public policy reasons why clarity here is important. Thank you.
All right. So I did have a chance, of course, as I said, to review the cases, review the briefs cited by the parties. Yeah, I totally see what you're saying, Mr. Trush, in terms of your need to have confidential communications with your clients, with Mr. Papp while they're incarcerated. And I think it does, to some degree, raise a public policy issue, because I don't think it's entirely clear that under the case law regarding attorney-client privilege, which requires communications to be confidential before the privilege even attaches, before we even get to Jolie and Amerson and all those others, we first have to find that the privilege applies. In those cases, that wasn't the question. And I think it is a question here in terms of JPay and whether that should or could be considered confidential to the extent that things that are said are subject to attorney-client privilege and then subject to the tests, which I agree with counsel. I think both of you that Jolie is the controlling case in terms of the test that needs to apply to privilege communications. And I agree, Mr. Church, with your argument as to Amerson, and that analysis would also apply to disqualification, because I think it would be, I think if a defendant satisfies the tests in Jolie for suppression, and those kind of communications have been reviewed by a prosecutor, I think necessarily a prosecutor probably should be disqualified, because they're then privy to specific defense strategies and so forth that they could take advantage of at trial. I'm not sure that the court or any court really needs to make a decision as to whether or not JPay communications are privileged, or whether email communications are privileged, or phone calls or video visits between an attorney and a defendant in a correctional facility. Because I think the Jolly test really provides the protection, as opposed to JPay being, a court ruling that JPay is or isn't privileged, or video visits are or aren't privileged. I think the protections in the three-pronged test in Jolie would adequately weed out any communications that would be privileged pursuant to JPay. And if they weren't privileged, I think that test, even if you applied that test to non-privileged communications or assume that they weren't privileged, it would provide an adequate protection. So I can't say, and I'm not going to make as part of my ruling whether or not the JPay communications between Mr. Trush and Mr. Papp in this case were privileged or were not, because I don't find that the Jolly test has been met by the defendant. So I don't think the court even needs to rule on that issue. I think I can assume for purposes of the motion that they were privileged. As I said, I do think it's an open question though. JPay, from the materials submitted by the prosecutor, clearly, states that those are not confidential communications. I did just some of my own research online with JPay to make myself familiar with that as a communication device, more than I have been just in the general processing of my cases. But it does, if it's not privileged, I understand the problem. But again, I don't know that it's a problem that needs a solution in light of Jolie. So assuming that the communications were privileged between Mr. Papp and Mr. Trush, number one, the court finds that the second prong of the Jolly test is not met, which is a deliberate intrusion. And I think this case is much different than the Jolly case from a factual standpoint, for the reasons stated by the prosecutor. In Jolly, the police believed that there was evidence on a computer. They got a search warrant to go into that computer. They found emails between the defendant in that case and his attorney, and then they used the information in those emails to obtain evidence. And that's much different than this case where at most, this was something that was discovered in the process of looking at evidence that clearly was not protected by the attorney-client privilege and statements to third parties by Mr. Papp. Further differentiating this case from Jolly is the prosecutor hasn't attempted to, number one, the prosecutor didn't go into JPay or subpoena JPay or try to discover those messages into JPay for the purpose of looking at attorney-client communications. The prosecutor, once he saw that there were some of those communications in there, he directed law enforcement not to open them. The prosecutor did not look at them. So there isn't anything before the court, even in terms of an offer of proof, that the prosecutor viewed those communications. Certainly there isn't anything to indicate that the prosecutor is going to, wants to, or would intend to use those communications. Part of the reason why I asked this question of the prosecutor, I mean, do you look at these in the course of all of your cases? And it's clear that this is an outlier in terms of prosecutor even having any access to JPay messages, because again, it's not something that the prosecutor, deliberately attempted to get as part of discovery to learn about some aspect of the case. It was something that came to the prosecutor surreptitiously through the course of what was part of the investigation that clearly did not involve privileged communications. So there wasn't a deliberate intrusion. And then the third prong, that there would be some type of prejudice. Again, because the prosecutor didn't review the messages between the defendant and the attorney, doesn't know what the content of those was, expressly directed that those not be divulged by law enforcement to the extent that they had them. The court finds that there wouldn't be any prejudice. So the court will deny the motion on that basis for failure to meet the second two prongs of the Jolie test. And again, from a public policy standpoint, because this isn't something that the prosecutor sought out to get, I don't know that, this is a problem that needs a solution at this time. But either way, regardless of whether they were privileged or not, assuming they were privileged, there was not an inappropriate viewing of those messages to the extent that the Jolie test is violated. So the court will deny the motion. Mr. Trush, I would request that you prepare an order reflecting the ruling of the court today.
This guy is just taking all the L's.
Yes, Your Honor, I'll get that prepared and sent over. With the court's permission, though, can I submit that Monday?
Yes. Yep.
Judge, if it'll make it Your Honor, if it'll make it any easier, I already have an order consistent. I did 3 different orders in anticipation of today's motion hearing. I've already got them prepared. I can send the one that I think accommodates what the court just ruled on to Mr. Trush, and then have it forwarded to you for your signature. He won't even have to prepare one unless the court would like to proceed in the original manner indicated.
No, that's fine. However you guys want to submit it, as long as we have an order, just to the extent
This way you can
that
have it today, Judge.
Okay. All right. Okay. Thank you. That's all for today then. And then we'll be back on the record in this file next week.
Okay.
Very good, thank you.
I'll be over to talk to you, Carl, on Monday.
All right, I'll
thank
be
you.
emailing you the proposed order in a moment. Thank you.
Mr. Papp, are you able to hear me?
Yes, sir.
Okay. Okay, we're on the record in People versus Carl Papp, file number 256857. The record should reflect Mr. Papp is present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
Morning, Your Honor, for the record, my call on behalf of the people.
Thank you, Your Honor. Richard Trush, hearing on behalf of Mr. Papp.
Okay, so this is set for final status conference today. I know at our previous hearing, Mr. Trush, you indicated that there may be a resolution of this case. Is that still correct?
Yes, we do anticipate that a plea will happen. I would indicate I appreciate the court signing an order that allowed Mr. Papp to be transported from MDOC and housed here. That has greatly improved our ability to communicate and ultimately get to a place to resolve this.
Okay. So what is the resolution? What's the terms of the plea?
So it would contemplate a plea to count one, and the habitual offender notice would be dismissed.
Mr. Rolo, is that a correct statement of the plea offer?
It is, Your Honor.
All right. Mr. Papp, were you able to hear that?
Yes, Your Honor.
And is that the plea agreement that you've discussed with Mr. Trush?
Yes, Your Honor.
Did you want to proceed with that plea today?
Yes, Your Honor.
Can you raise your right hand, please?
And Your Honor, just one point I want to clarify for Mr. Papp, because he asked me this before. I think in the original felony complaint in the district court, the 25-year mandatory minimum, I think it was on the original complaint. The information that I have does not. It contemplates over 13 but under 16. And I know he raised that to me. My information doesn't reflect it, but I just want to make sure we're all speaking the same language.
So that's correct, Judge. That's why it was amended.
Okay.
Because the original information was based upon the incident occurring prior to the age of 13 at preliminary examination. That was not the testimony. So the information was amended to reflect 13 to 15.
Okay. Mr. Papp, did you have any questions about that?
No, Your Honor.
Okay. If you could raise your right hand again, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Papp, you understand that by pleading guilty to count one, which is criminal sexual conduct first degree, that the maximum possible penalty that you could face would be life in prison, along with mandatory lifetime electronic monitoring. Do you understand that?
Yes, Your Honor.
Mr. Trush, is there any circumstances here that would call for any kind of consecutive sentencing to his current sentence?
I don't believe so, because of effectively late reporting, I think the event here predates the other, so he wasn't on like bond or anything like that.
Okay. All right. So, Mr. Papp, with that maximum possible penalty in mind, then what is your plea to that charge today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor.
And you understand that you're going to be giving up and waiving all of those rights, and you won't have them anymore, and that includes the right to have a jury trial. Do you understand that?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty of this charge?
Yes, Your Honor.
All right. Mr. Trush, can you conduct the questioning of your client to establish the factual basis?
Yeah, so Mr. Papp, in March or around the time of March of 2023, were you here in Otsego County?
Yes.
And did you engage in sexual intercourse with a minor with the initials LL?
Yes, sir.
And at the time of that, was she under the age of 16?
By a few months.
And at the time that that occurred, were you in your 30s?
Yes, sir.
See, and that right there is how you know that he doesn't take it seriously and he doesn't really care. Because when they asked him, was she under the age of 16, rather than taking full responsibility and accountability for it, he minimizes it by saying, by a few months. As if it makes it better. It doesn't. You're gross.
Your Honor, I think that would establish a factual basis.
Mr. Papp, by sexual intercourse, does that mean penile vaginal penetration?
Yes, Your Honor.
And were you members of the same household at that time?
Yes, Your Honor.
All right, Mr. Rolla, are you satisfied with the factual basis?
One additional question with the court's permission.
Sure.
Mr. Papp, were you also acting in a position of authority, being a member of that household with the minor LL?
What do you mean by that?
Were you acting where you sometimes took care of her where her mother wasn't available?
Her mother was always available. I don't know. But to be honest, I don't understand the question. Like, what do you mean by that? Like, I paid bills, I took care of the house.
So if I could clarify, I think what he's trying to ask you, Mr. Papp, is you were not the minor's parent, but were you acting almost like a step parent?
Oh, then yes, Your Honor.
Okay.
Very good, Your Honor. Thank you. The people are now satisfied that a sufficient factual basis. Oh, we need to have venue though, Your Honor.
We did.
Oh, we did? Okay, then I missed that. Then the people are satisfied, of course, sufficient factual basis to accept the defendant's guilty plea to count one as charged.
All right. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
None by the people, thank you.
I guess one more question following up on venue. Maybe it wasn't entirely clear. Mr. Papp, I know you said that you were in Otsego County in the time frame of March of 2023, but did the sexual intercourse actually take place in Otsego County?
Yes, Your Honor.
Okay.
Very good, thank you.
Outside of that, counsel, are you both satisfied that the court has complied with statute and foregoing the taking of this plea?
People are satisfied, thank you.
Yes, Your Honor.
All right. Mr. Papp, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. We'll set this matter for a sentencing hearing. Mr. Trush, do you want to have Mr. Papp remain lodged here, or?
So I did discuss this with him. He would prefer to be transported back to MDOC. Given that this is going to be a PSI update, so I mean, other than the scoring information and the recommendations, I think effectively everything else is going to be identical to the PSI that was done in the other case. I don't have any objection to him being transported back. He did indicate though that he would like to be present for the sentencing. So,
All right, I'm not going to do the back and forth. So.
Well, if that's the case, Your Honor, I'll do it over Zoom so I can go back to the MDOC.
Okay, all right. Mr. Trush, is that something you want?
Yes, I'd rather go back to the MDOC.
So I have no objection to that. The court may recall, I mean, part of what prompted me to ask him to be transported was I became concerned that my communications with him were not being confidential.
Sure.
At this stage, I think that's less of a concern. I don't expect our strategy in terms of the PSI and how we're going to approach sentencing are particularly novel.
Mm-hmm. Okay. Yeah, I mean, I can't justify the expense because that's the preference, you know what I'm saying? So I'm happy to have an in-person sentencing. I would have Mr. Papp stay here, but Mr. Papp, you indicate pretty clearly that you would waive your right to the in-person sentencing so that you could go back to DOC?
Yes, Your Honor.
Okay. All right, so we'll schedule it as a sentencing by Zoom. So Mr. Roloff, you can prepare the writ that way.
Making notes to that effect, thank you, Your Honor.
Okay. Mr. Roll, anything further on this file today?
Not for the people, thank you.
Mr. Church?
Just a question in terms of the transport back. I mean, does the court need me to prepare an order or something to
Actually,
effectuate
was
that?
covered in the original order.
Honestly, I don't know. I'm happy to sign an order. I don't know what Department of Corrections requires for them to come to pick them up. I don't know if just communication with the jail is enough, but either at your request or the request of the jail, I'm happy to sign any orders that are needed.
I will just prophylactically create a order.
Okay. Then also in light of the plea today, the court will adjourn the jury trial that's set for next week.
On that note, Judge, and I understand it's not this case, but there was also another trial scheduled during that time period. Is that trial going to be on?
We saw Mr.
Thursday, I believe. Judge?
Yeah,
We,
Jason Thompson, he's on our
Is that
docket
Thompson?
today.
yeah, so we have a final status conference on that today.
Okay.
I would indicate, I don't know exactly.
Mr.
where-
Thompson is connected, so I can bring him in here in a second.
Okay. I spoke to him last night and was under the impression he was going to be here.
I thought we had already approved a Zoom appearance for him.
We had previously at one hearing, but I mean, at least I didn't submit anything for this hearing.
Well, we'll go forward with it regardless. Mr. Papp, we're going to go ahead and disconnect. Thank you.
Right, thank you.
All right, Mr. Trush, you ready on Mr. Papp's case?
Yes, sure.
Mr. Papp, are you able to hear me okay?
Yes, sir.
All right, 1 second. All right, we'll go on the record in People versus Carl Papp. This is file number 256857. Mr. Rolla, I do have Miss Daniels in the.
I was going to say, Judge, I thought she was appearing, but apparently she's appearing via Zoom.
All right.
All right, again.
That's Miss. Well, yeah, you know what? Due to the nature of this case,
So due to the nature of the case, the judge took the sentencing hearing off of YouTube because the victim appeared by Zoom. But this is what the outcome of the case is. He was sentenced to prison. All charges concurrent with any other sentencings. His sentence was to begin that day, 1/20/26, for a minimum of 135 months and a maximum of 40 years. And it's not over, because what drew my attention to this case at all was a hearing I saw today. And we're going to watch that now.
Mr. Papp, are you able to hear me okay?
Yeah, can you hear me?
I can, yes, thank you.
Well, can I ask a couple questions before we get this started?
Yep, let me just call your case real quick and then certainly do that.
Thank you.
We're on the record now in People versus Carl Papp. This is file number 256857. The record should reflect Mr. Papp is appearing today by video from Department of Corrections. If I could have counsel put your appearances on.
Good morning, Your Honor. For the record, Michael, on behalf of the people.
Thank you, Your Honor. Richard Trushbury on behalf of the Papp.
Okay, thank you. So we're here for sentencing issue that the court was made aware of by Department of Corrections. But before we get to that, Mr. Papp, you indicated there was something you wanted to say.
Yeah, I was just curious, a couple questions if you could answer for me, because I've been trying to get this answered this year long, but this is actually over a year this has been going on.
Oh, his voice. Oh, how did he get anyone interested in him at all with that voice?
Bruce is yet to give me a very definitive answer. The other, the district court kind of said something, but I want to make sure, is a preliminary and evidentiary hearing the same thing?
No, I mean, they
I
are
didn't
sort
think-
of. A preliminary hearing is an evidentiary hearing, but there's all kinds of evidentiary type hearings. Preliminary hearing is a type of evidentiary hearing.
What about is it the same thing as a probable cause conference?
You know, now we're getting into the area where I'm not just defining things. I'm giving you advice.
Because the only reason, I don't mean to cut you off, John, the only reason I'm asking is because I never had a proper cause, and I've told Richard this from the get-go. I never had a proper cause. I had an evidentiary hearing. I never had a proper cause. They scheduled it before he was my attorney, but I never went to it, which I kept telling him there's a violation of my due process. But the second thing is, I just got back from the law library before I had this meeting, so I wanted to make sure I don't sound stupid when I'm talking to you. That I'm just curious, and my appellate attorney told me to ask, how is it that they retain a warrant when myself and the so-called victim said this never happened, even testified in front of the district court, I didn't do this, and yet they still went and got a warrant off of a third-party hearsay, which in the Michigan court law states you cannot grant or get a warrant off of hearsay. They have to have proper, like, identifying evidence, in which the victim saying, I did this, which we had an affidavit signed. I don't know if Richard ever turned it into the courts, where Lauren said, I never did this. And then my last thing is, I was never told about a tether until like a month ago from the Department of Corrections. Because I would have never accepted this plea. I would make sure that they took that off there. Because that hinders my job. Because a person might be like, hey, why you have that? I'm not hiring you. Because as you probably noted in my PSI, I run my own business. And I'm going to continue to do that when I get out. But if a person sees like this thing, they're like, whoa, oh, you're an alcoholic, maybe, because they maybe think it's alcoholic monitor system or something. They're going to assume that I'm a problem and not want to hire me within it, for it hinders my livelihood to support me and my family.
Okay.
Because I was never told this legit, but this whole time, no one ever told me if that's a possibility you could get this. So I'm asking the courts if they would, as the thing I got from the MDOC is to amend it where it is, because that was never brought to me, which I feel that should have been something Richard due diligence, like, hey, you know, by accepting this is also a possibility they might not make you, but they can make you. He's never informed me of that in any way, shape, or form to this whole process.
Okay.
This is pretty much accept this plea. This is the best thing you're going to get. If pretty much not, I'm going to spend the rest of my life here. I was like, well, I want to be out one day to see my son.
Okay,
But that was
so
never a part of it. Go ahead.
just let me know when you're done, because every
I'm
time
done.
I start
Sorry.
talking, you start talking again. So I want you to say whatever you want to say, but just let me know once you're done so that I can answer your
I'm done.
questions.
Go ahead, Your Honor.
I want to get out of here one day to see my son, the child you created with the victim. Oh my.
Okay. All right, so the things you raised about the probable cause conference, the warrant, those are both issues that you can raise on appeal. That's not something that's before me to make a decision on today. But those are grounds that your appellate attorney, I'm assuming, you know, you guys will talk about that, and those are things that can be raised on appeal. With regard to the lifetime electronic monitoring, They're two separate issues that we're raising here on that today. You're raising the argument that you weren't aware that that was something that was going to be a consequence of your sentence. That argument also is something for appeal, to tell the Court of Appeals, you should vacate my plea because I wasn't properly advised of this consequence. And the Court of Appeals will decide that. So that is also an issue for appeal. Why I set this hearing is by statute, based on your conviction, I have to impose that. And that was something as an oversight or a clerical error that the court failed to do at sentencing. But the fact that I'm required by statute to impose it is a different issue than whether you were properly advised of the consequence of that, and that you might have not entered your plea if you had known about that. That's an appellate issue. Do you see the difference between those two things?
Yes, Your Honor. So my next question is, what happens, so if I move out of Michigan, because like Tennessee, where I'm thinking about moving to, doesn't require me to do that? Because this is, from understand, this is just a Michigan law. It's not a countrywide law, it's a Michigan state law. So if I move out of Michigan, technically that does not abide to me, if I'm not mistaken, right?
I do not know. That's something that the parole board would address with you when you're released on parole.
And then my next thing was, because I know this is part of your court, from what it looks like, I'm about to beat my gun charges. It looks very good on that right now. Would I get rescored, not just my time back for that about year, which you already agreed to I would, but would I get rescored because after doing my guidelines, it drops it down like another 2 years on top of that?
Yeah, again, that would be an issue for your appellate attorneys to advise you on. That's, I have no idea what effect it might or might not have. And sitting here today, there's no way for me to know that.
All right.
But that's something that your appellate attorneys would give you legal advice on, the effect of having any conviction vacated, what that would mean for subsequent convictions.
Well, they told me it'd be up to you because it technically, as like you already agreed, it would go back. If I do beat the gun charges, I'm going back in front of you to get resentenced on this very case to knock that, give me my year back. And then on top of that, if I'm just asking for the record, would you allow me to get rescored on top of that then? Because by being because they told me if you take off my 2 gun charges in the 4th degree habitual, it's going to drop my time down. Even if you, again, like how you did max me out to touch my max guidelines, it's going to knock it down another 2 to 2.5 years.
Yeah,
which
so
therefore
that very well may end up back in this court if all of that happens. And if it does, then I'll have briefing from your attorney and from the prosecutor. I'll have a report from the Department of Corrections. And you're right. I mean, ultimately, I might have to make a decision on that. But sitting here today without any of that information and without knowing whether or not that's even going to happen, I can't give you an idea of what I might or might not do a year from now, having all of that information that now I don't have any of that. So I can't tell you what I might or might not do or what the law may or may not allow. So.
Thank you. I just wanted to get some stuff for the record. So when my appellate attorney gets to look at this, because we've both been just dumbfounded by how this whole thing has went down and just how things legit happen, especially when the victim says this never happened and yet I'm forced to take a plea or get 30 years.
Well, I mean, you got her pregnant, so something happened.
But she already been. But even then, we asked, like, well, not in your courtroom, in district court, how Hubbard went about this, because what they didn't tell you, there's been 3 tests, and which is weird, 2 of them came back not mine. One of them all of a sudden did on the very last one that Hubbard brought from Newberry down to wherever the state lab is, which is kind of weird in itself.
All right.
But
well,
it is what
either way,
it is.
we're not going to relitigate your case here this morning. That's something that you can address all of those things on appeal. What we're here for this morning is, again, the error by the court in not imposing lifetime electronic monitoring at the time of sentencing, which the court was required to do. I did review the transcript from the sentencing hearing, and the court did not articulate that for the record. Mr. Rolla, on behalf of the people, do you take any position on this?
Oh no. Where did Mr. Rolla's sound go? I think when I enhanced it, this is about the point where I fell asleep, guys. I think I muted Mr. Rolla. Hold on, hold on. Here's what we're gonna do. I'm going to go to I'll get it, don't worry guys. I did. I muted Mr. Rolla. I'm naughty. I'm sorry. That's what I get for sleep editing. Oh, what is that? 46th. 46th District Court. And that's gonna be this one. Okay, here we go.
Okay.
I won't make you re-listen to all of his brilliance.
In itself.
All right.
But
Well,
it is what
either
it
way,
is.
we're not going to relitigate your case here this
Yeah.
morning. That's something that you can address all of those things on appeal. What we're here for this morning is, again, the error by the court in not imposing lifetime electronic monitoring at the time of sentencing, which the court was required to do. I did review the transcript from the sentencing hearing, and the court did not articulate that for the record. Mr. Rolla, on behalf of the people, do you take any position on this?
Judge, pursuant to the holdings in People versus King, that's Michigan Court of Appeals 297, Michigan 465, 824 Northwest Second 258. It's a 2012 case, and People versus Comer by Michigan Supreme Court 500-278, 901 Northwest Second 553, a 2017 case. They specifically affirm what the Department of Corrections indicated, that for this particular offense, it is mandatory lifetime sentence.
Mr. Trush.
Your Honor, to the extent that Mr. Papp has not already preserved his objection to it by his statements, for his benefit, I would indicate he does object to it. Obviously, he's raised an objection on the basis of not being aware of that as a potential consequence. Additionally, when I communicated with him prior to this hearing, he had raised an objection to me based on it. But effectively, I touched on this when he spoke, but I don't think he articulated it the same way, being a limitation on his ability to basically travel between states. So again, to the extent that he hasn't already preserved those with his statements, I would specifically object on those bases.
Okay, so those objections are all preserved for the record. From my standpoint, based on the conviction in and of itself, the statute does require the court to impose lifetime electronic monitoring. So subject to the objections and appeals, the court will impose that at this time. So we'll have an amended judgment of sentence that will reflect that. Mr. Rolla, is there anything further today?
Not in this case. Thank you, Judge.
Mr. Trush.
No, thank you, Your Honor.
Mr. Papp, we're going to go ahead and disconnect at this time. Thank you.
All right, thank you.
Aww, his dumb face took another L. I'm just glad I knew exactly where that raw file was. Yeah. At least I didn't blame it on the cats. Yeah, Earl and Snitch both. Well, Snitch, he's holding that butterfly toy. He's holding it hostage. He's not letting it move. Oh, Earl does not like him. Earl doesn't like him a whole lot. Hey, buddy. Hey, buddy, you holding that butterfly hostage? That poor butterfly. That poor butterfly. Hi. I love you. Golly, I love your face. Oh, guys. Oh, yeah, like it's gonna matter. All of his charges are consecutive. It's not gonna matter. I mean, that's just, but it's a year. Well, yeah, but it's not actually a year you're doing any extra time for. All of your time is wrapped up in your SO. I love that. Oh, you can see Billy at the door and Ava at the door. Yeah, Billy's on the floor. And Earl's on the bed. You can't see him though because of the door. Yeah, it's gonna matter. He's not gonna live 40 more years. He's 40 now. Or no. I'm bad. Nope. He's 30 now. In his 30s. Gotta put on my Jerry nightgown. I'm wearing my Charlie shirt. No, this is soft and comfy and fuzzy, and I love it so much. Well, not fuzzy, but it's super, super soft and comfy, and I love it so much. This is my favorite shirt. It makes me look like I'm sparkly. Oh, man. These allergies are brutal. And this snuffly stuff, it just needs to stop. My eyes are so, like, glassy and watery. Oh, people are going to start thinking I'm not sober when I'm streaming. I am. I swear I am. I'm just on Dayquil. Yeah. Yep, I talked to her today. She's going through the same stuff I'm going through, but she's treating it by sleeping. So, she's alright, guys. Oh, I haven't touched it. Not a drop. I don't drink. I don't drink at all. Completely untouched. Unsullied. Guilty or not guilty. But I keep it close because I love it. She's gonna love to know that all of you guys are thinking about her. Yep, I sent her a video of me giving Earl a kiss earlier today. And telling him he's handsome. Alright, guys. I am going to go to bed now. Because in 6 hours or less, I have to be up collecting more court dockets so that I can find more stuff. Ava's over there trying to play with the kitties. Yes, thank you everyone. Nana Laura, I don't care what time it is. If anything happens, please shoot me a text, let me know. I love you so much. I love all of you guys. Jerry, good luck at your surgery tomorrow. Be safe, be well, sleep sweet, and much love.